Hello, all. Welcome to another session of this course titled Legal Essentials for Human Resource Management. If you remember, this is week 2 and session 9 of this course. The course is designed in such a way that it looks into a natural progression of tasks done by a HR manager, and we started off with drafting of employment contract. So you have a job role to offer. In that job role there was a candidate who has shown interest. We have kind of interviewed him. He is has been selected, and next stage is giving him a offer letter, which is a draft employment contract, and the employee and the employer signs it. It becomes a employment contract, and we discussed it could be fixed term, permanent, what are the various provisions and clauses that you can include in an employment contract, what are the various restrictions you could involve in a labor contract. So we have all discussed those things. Now, once an employee or a worker gets into a workplace, first thing he should know is that what are the general rules and regulations at this place. Often along with the offer letter, along with the employment contract, these rules and regulations are provided to the employees or workers. So you may be surprised or rather interested to know that there is a legal requirement to do this. That every employee should be aware of various rules and regulations that are there at his workplace. And the law that governs this particular aspect is called as Standing Orders Act. So today's session and tomorrow's session, next two sessions are gonna be about the Standing Orders Act and what are the various provisions according to it. So without much delay, let's get into the discussion. And as you are already familiar, my name is Dr. Amish Samalopanan and I am from Nalsa University of Law. So what is the context of this act? Or what is the context of all this discussion? Now imagine a worker is entering the labor market. Now, he may not know the conditions and terms of employment which is prevalent at his workplace. Of course, what drives him to the work is that he needs a livelihood. He just walks in, he's new into the place, he doesn't know what is the exact amount of salary that would be paid, probably what is the duration of work per day, when can I take leave, how to take leave. Employee may not be knowing it, especially workers whom you know is not somebody who is in a managerial position. He may not be knowing this. Since the employee or the worker may not be knowing this, the employer can exploit the lack of knowledge. You ask for the leave, you could just ask, no, we don't provide any leave here. You just go back and work. What will you say? So it would be really unfair that if the employer start exploiting the workers just because he is not aware of his rights. Hence, this particular act has come in, which is called as Industrial Employment Standing Orders Act of 1946, which stipulates that the employer should define the terms and conditions of employment with sufficient clarity and apply the same uniformly to the workers. The reason why we say uniformly to the workers is because often this lack of knowledge can lead to improper treatment. For example, there is an employee B, he knows, if you apply this leave to this particular officer, he has to give me leave. So he, just because he knows that information, he gets leave. But another guy doesn't know this, and you as an employer also know this, he doesn't know this. So you can exploit him. So the Act says the terms and conditions of employment has to be predefined and well defined with sufficient clarity, and it has to be applied uniformly to the workers. Now let's look at the applicability of this Act. Now, this act is applicable to any industrial establishment where 100 or more workmen are employed. So, we have a number. If there is an industrial establishment, understand what is industry. One of our previous classes, we have discussed what is industry, where there is a industrial work happening and there is employee-employee relationship, and goods and services for the benefit of human being has been produced. Now that becomes industry, and industry having more than 100 people in any day preceding 12 months. So this clause, that any day preceding 12 months, is a common clause you will see in a lot of act. This is to ensure that the employer does not do chopping of the employees just to become compliant. You know that there is going to be a labor officer that would come for an inspection. You suddenly fire few people, and suddenly you don't no longer have to follow that particular act. Such things shouldn't happen. So the act clearly says that there should be 100 employees in 12 months preceding this date, any 12 months before. So 1 year, in the last 1 year, at any point of time, you had 100 workmen employed under you, you are compliant to this particular act. So, which also means that if at any point the number falls below 100, this act will continue to apply. Now, we discussed that new age, there are some labor codes that are coming up, and in the not yet applicable labor codes, this particular section is covered under IR code, Industrial Relations Code, and the threshold for applicability has been increased to 300 workers. So most likely by the time when you study this or when you start applying this, you would realize that the threshold has been increased to 300. This act also says the appropriate government can, after giving not less than 2 months notice to the employer, can apply the provisions of act to an industrial establishment even if they have less than 100 people. Sometimes you realize that this particular industry, there it is very important to have clear terms of employment. So the appropriate government by a notification can say that, okay, if you belong to this particular industry, even if you have less than 100 employees, you need to have applicability of standing orders, which means that your terms of employment has to be well defined. Now, how this works is that, imagine you work at an industrial establishment where there is no Standing Orders Act. Now, this is a rarity. Often, when you start working, if it is an already existing establishment, they would be having a standing orders for sure, or rather, they're on rules and regulations for sure. But let's imagine it's a new organization, it's a new establishment. You are like the founding HR person, or you started this establishment. So within 6 months of the act becoming applicable, which means you started off, let's say you had 50 employees, 50 workers. Please do ensure that it's workers. 50 workers, 60, 70, 80, 90, and one fine day it crosses 100. Now, from that point, within 6 months, the employer is required to submit to the certifying officer, who is the labor commissioner or a regional labor commissioner. I mean, one of those certifying officer who is allocated. 5 copies of the draft standing orders proposed for the industrial establishment. So let's say you have an industrial establishment, it started growing, and one fine day it has more than 100 workers. Within 6 months, you have to prepare a draft standing order, which is like model terms of the employment. To help this, there are a draft available already in the Labor Commission website. So you can download it, and then of course a lot of provisions may not be applied to it. A lot more would be applying to it. So you tweak it and all that. That's why the 6 month has been given. With the after 6 months, you submit it to the certifying officer, and you should submit 5 copies of the draft. Now, there are a few elements that should be included in the draft standing orders. I'll discuss that in a while. Ensure that you provide all the matters that is mentioned in the schedule. And along with the draft standing order, you should also be giving particulars of the workmen employed in the industrial establishment, their name, the trade union they belong to. We haven't discussed the trade union in detail. In the upcoming sessions, we would be. So, and worker would be part of any of the trade unions. So, that details also you can give, and it has to be submitted to the certifying officer. Now, let's say you started this business or a industrial establishment. Somebody whom you know also have started a similar establishment. Let's say you make pickles, achars you make of mango, and this guy also makes achars. More or less, you use the similar machines. The nature of work is similar. If that's the case, according to section 32 of IR code, you can submit a joint draft standing order also. You may not have to prepare different standing orders. You can submit a joint standing orders. Now, it becomes the duty of the employer to consult trade unions. I understand the word trade union is coming very often, and that makes me realize that sooner I have to go through the Trade Unions Act. So probably we'll dedicate a week for trade unions sooner or later. So they need to consult the trade unions or any negotiating unions or members of the negotiating council. So these words I understand doesn't make sense now, given that you're not aware of provisions of Trade Union Act. But I'm sure as trade unions are a group of workmen coming together so that they have a collective voice against the employer, because individually they may not be that powerful, but as a collective, when they come together, they have what we call as a collective bargaining power. That's the whole purpose of setting up of trade unions. The intricacies we'll discuss going forward while we discuss the week dedicated for industrial disputes and industrial relations. So it is mandatory that the employer consult trade unions or negotiating unions and get their feedback. Now, I told you there is a model standing order given in the with the government itself in the Labor Commissioner website. Now, if you accept it without change, it is deemed to be certified. You just need to formally inform your certifying officer that we are taking the standing orders, model standing orders as it is. So this is another provision of Industrial Relations Code. So it is there, but often it can happen that you need to add in certain terms more than what is provided in the model standing orders. So of course you will make some tweaks. So that tweaks has to be consulted with the trade unions also. You have to take them into confidence. I'll tell you why is it required. It is required because in the process of acceptance, this will again go back to the trade unions for their opinion. The certifying officer will send this back to the trade union members or trade unions, and then only they will accept. So it's better that we start off by consulting with them so that we don't have to waste time in later stage. Now, what are the matters to be provided in the draft standing orders? First and foremost, be very clear about the classification of workmen. Is there a permanent category, temporary category, apprentice, probationer, badali, or fixed term employment? What all classifications are there? Be very clear about it, because some of these provisions would be different for certain classification. So please explain the classification, define the classification so that everybody knows ki where do I belong to and what applies to me. Now, workman's tickets and registers, which workman's ticket is essentially an old term because it's an act which is very old. So before the timings of the employees and workmen were measured through tickets. Like you enter to the job, you collect the ticket, then you submit back the ticket, you know the time duration the worker has spent. Here, what happens is that the what is the time duration expected out of you? This has to be very clear. What are the registers that would be maintained? One would be attendance register, one would be leave register. What would be the various registers? That has to be very clear. How will the workman be intimated regarding the periods of hours of work, holiday, pay days, wage rate, vagera? So it has to be fixed, and how it will be informed to the workman. It also has to be very clearly explained. What is the provisions of shift working? Can there be a shift working? What are the rules regarding the shift working? How is it arranged? That has to be clearly mentioned. What are the rules regarding attendance and late coming? Up to what time you can come late, and after which it would be a half day? After what time it would be a full day absence? Managerial roles, people who play managerial roles or supervisory roles cannot abruptly take calls on it because he prefers certain worker. Oh, it's okay for you to come late. It should not happen that way. That's why the rules cannot be discriminatory and preferential. That's the whole purpose of the standing orders. So there should be a clarity in terms of what is the attendance policy and what is the late coming policy. What is the procedure for applying for leaves, for grants, for holidays? Please explain. If you don't explain, the worker doesn't know how to apply, and because of which he is not able to apply. Such confusion shouldn't happen. So please explain the procedure for applying and to whom to apply to, the authority which may grant leave and holidays. Is there any particular requirements to enter the premises of by gate? You might say that without a identity card you may not be able to enter. So if that is the rule, please mention it in the standing orders. Similarly, will they be searched while entering and going? You cannot just add in this as a practice in between. To be very clear about it in the standing order so that there is no confusion going forward later. What are the various clauses of termination of employment? And what notice thereof to be given by the employer? What is the notice period that would be given? What is the procedure to conduct any sort of inquiries for misconduct? What becomes misconduct, what doesn't become misconduct? If there are varying levels of misconduct, what are the various levels? This is level 1 misconduct, level 2 misconduct, level 3 misconduct. Those things be very clear in the standing orders. If the workman has any sort of issue And he needs a redressal against any of the unfair treatment or wrongful exactions by the employer or his agents or his servants. By anybody at the workplace, there should be a redressal mechanism to go and speak to. So please explain what would be that redressal mechanism. Now these are all statutory requirement. We'll discuss Industrial Dispute Act and the IR code in detail in the week which we have earmarked for industrial relations. Then you'll realize that it is a legal mandate that you have such redressal forums where workmen will come and share his grievances. What is the age for retirement or superannuation? Be very clear. Employment or re-employment for probationers or badlis or temporary or casual workmen. So sometimes it happens that probationers, we have discussed this in the employment contract, the concept of probation. The concept of probation says that up to one maximum of 2 years, you can keep a worker or an employee under probation just to see if his performance is satisfactory or not. And if the performance is not satisfactory, you can extend the probation or maybe even terminate the employment. So please understand that these information has to be told in the beginning. Employment contract most often will have these clauses, but it emerges from the existing standing orders. So please understand. And let's say the probationer was terminated. Is there any way of re-employment for people or a re-employment for the casual workmen? Or no, such details has to be given. What would be the various service record matters relating to the service card, token tickets, certification of service, change of residential address or workers, or age? What are the, how can we change this? A lot of people want to change it but don't know how to do it. So what are the ways you can change it? Age of retirement, as I explained. What are the medical aid that would be provided in various cases of accidents? It's another thing. So in total, I mean, this is not the complete list, it's just an indicative list of what are the matters to be provided in the draft standing orders. It's well given in the Schedule 1 of the Standing Orders Act. People who are interested can just Google the Standing Orders Act and you'll get the act. You scroll to the last portion, you'll see a Schedule 1, and then you can read and understand various matters to be provided in the draft standing orders. Now, if you recall what we have discussed till now, we are saying that we have an industrial establishment where one fine day we crossed the threshold of 100 workmen. Now we are discussing what can be done, right? So we said that first, within 6 months, pull out the model standing orders provided in the website, make necessary additions in terms of various matters that we have discussed till now, have a discussion with the trade union also while you are introducing all these concepts. After that, submit 5 copies to the certifying officer. So let's take a pause there. What happens to the submitted standing orders? How does it get approved? Once it gets approved, what will happen? What will happen if you don't have a standing order at all despite reaching the threshold? All the factors we'll discuss in the next class. Thank you so much for your patient listening. For the time being, let's take a small break of this discussion on standing orders. Let's pick it up in the next class. Till then, thank you so much. You have a great day ahead.